Ma'am, your full name and date of birth, please.
Carmen Garcia, 9/25/1992.
And counsel.
Matthew Bartron on behalf of Gabriel Garcia, who is present. We're appearing for the initial appearance.
All right, and
David Foster on behalf of the state, Your Honor.
all right, thank you. Let's talk about the counsel issue briefly. As you've noted, it was for the initial appearance only. My typical practice counsel in this matter, or in this situation, I should say, is when the individual otherwise qualifies for court-appointed counsel, I go ahead and appoint just on the off chance that there's no meeting of the minds between you. Would you like me to proceed that way?
Yes.
All right, ma'am, so I'm going to appoint a lawyer for you just on the off chance that you and Mr. Bart don't come to an agreement where he ends up representing you throughout the entire case. Because right now, with the document that he's filed, he's only committing to the court to represent you right now for this hearing also. So you probably have some further discussions that you two need to do. And then once he makes the commitment to the court to represent you throughout the entirety of the case, then that lawyer that I appoint for you goes away and Mr. Bartz will represent you. Do you understand that? All right. The whole reason I do that is because I don't want you to ever be without a lawyer while this case is going. Do you understand that? All right. So with that understanding, the court will go ahead and appoint counsel. And again, that counsel will step down if necessary. All right, ma'am, you are here on 4 allegations of furnishing obscene materials to minors. Those are class 4 felonies. I have reviewed the Form 4, and counsel, I believe you received a copy. Is that correct? All right. And right now, I'm only finding probable cause out of 2 out of those 4, unless the state has additional information.
The state does not, Your Honor.
All right. So there's probable cause for right now, ma'am, is based on the information that I received on 2 of those 4. That doesn't mean that those 4 are gone or dismissed, as your lawyer will explain to you. What a no probable cause finding at this stage essentially means is if the state wishes to proceed with those additional allegations, they need to provide more information to the court about what they believe happened. All right? All right. All right. Does the state wish to be heard with respect to release conditions?
Yes, Your Honor. Given the nature of the allegations, the nature of the victims present, it's allegedly videotaped, and the subject is in a position of trust. The state's requesting electronic monitoring with supervision, no minor contact, as well, Your Honor, as no contact with co-defendants.
Mr. Bartz?
Yes, Your Honor. Just to address part of what the state said, and it goes along with the finding of probable cause that the court made, the defense would argue that it's very possible, based on the information contained in this Form 4, that there actually were no victims that witnessed or were shown this conduct by my client. This latter third of the probable cause statement lays out the officer's explanation of what they had done while watching the video. And while they do explain my client as being involved in what would be described as obscene behavior with this item, they do not specify that any children were actually present, shown, or witnessed for conduct and behavior. As to the co-defendant, they clearly state that the co-defendant provided that object to a minor child. But as to my client, they don't specifically explain that anybody was present and witnessed it. I am aware that one of the managers of this facility earlier stated to the officers that children were seen in the video, but they don't specify at what point. It's very clear that a child is present when a co-defendant hands this object to a child, but it's not clear that children observed or were shown my client's behavior. Based off of that, and the fact that my client is a 25-year-old single mother, she's a high school graduate, she attends a local college, she's resided in Arizona since she was 10 years old, she has strong local ties, her mother, her 2 sisters, her aunts, her cousins reside here. She has no passport to be able to flee. She'd been employed at this daycare facility for over a year and had been gainfully employed until she was terminated. She has no prior criminal history at all. We would request that the court release her on her own recognizance without electronic monitoring.
Do you have additional information? On probable cause or release?
On release, Your Honor.
Go ahead, and I'll give counsel one reply or rebuttal, whatever it's called, but a brief one.
Your Honor, simply stated, she was present when it was handed to the trial. The state also would argue potentially accomplice liability if she never left the room and was aware that it was handed to the trial and is continuing that behavior. So whether the argument of we don't know that there were children present, we know there were children present. The Form 4 clearly states that. The electronic monitors is to assure presence at trial and the safety of the community and no future contact with minors, Judge.
Brief reply or rebuttal if you want.
If the court makes the final probable cause, we would just ask that she be released on her own.
All right. Prior to court starting, I did review the Form 4 and initially had probable cause issues as well, not only as to the 4 counts versus the 2 counts, but as to whether or not there was probable cause for anything. I did take a look at the statute, 13-3506, and there are enough verbs in that statute that allows a finding of probable cause, and I'm basing that on the description of the video in its totality. I believe there's at least probable cause that the 1 or 2 children were present in the general area while this was going on. Whether they were all napping or not, I can't make any findings on with respect, and that will all have to get fleshed out as the discovery process takes place and or other proceedings. So I am going to maintain the finding of probable cause with respect to 2 of the 4 counts. With respect to release conditions, the court did review the criminal history information provided to me, and there appears to be none other than this arrest, according again to the information being given to me. The court takes note of the defendant's contacts with the community. The court takes note of the self-surrender that occurred prior to today's court appearance. You mentioned, Mr. Bartz, your client's a single mother. How old is the child?
5 years old.
Do you have any information or awareness as to have there been any prior DCS contacts with your client and DCS?
I asked her about that. She says that DCS has not been.
Ever? How many children do you have, ma'am? All right. Taking into account everything that we have just talked about, I do not perceive the Ms. Garcia to be a flight risk. She did self-surrender. She has taken steps to retain counsel. She does have ties to the community. The allegations, if proved, are offensive, but they are allegations at this point, albeit with alleged video evidence. Purpose of pretrial release decisions is not to punish, but to make reasonable assurances as to the safety of the community, others, and the defendant's appearance at trial. Weighing all of that and those purposes, I am going to release you on your own recognizance, so that means your own promise to appear in court and remain law-abiding. Next court date, counsel, and this appears to be a Southeast Judicial case, so at the Javelina Avenue facility. The next court date is for a status conference on October 26th at 8:30, and preliminary hearing is presently scheduled for November 1st at 8:30, both at SEC 04. And you have the following release conditions. You are not to return to the scene of the alleged crime, no contact with any of the alleged victims or witnesses or arresting officers or your co-defendants, no contacts with minors other than your own child, no drugs without a prescription, bring proof of a good address with you when you come to court on the 26th. Does the state have any suggestions with respect to release conditions other than what's been stated?
Nothing more than has been addressed by the court.
All right. Anything you'd want to add, Mr. Barnes? All right. So that'll be the order. So again, October 26th, ma'am, is your next court date. And if you step to the right and sign, you'll get your written copy of everything. All right. Thank you, counsel.